Hello again. So this is the continuation of the first video regarding the subject of administrative law. As your reference and as the basis of law of our discussion of this topic, you have to read these three regulations. These three regulations is talking about administrative court. Of course, there are also other regulations regarding this, but this is the first step that you have to do to read this regulation. So based on this regulation, we can determine the subject of law, the subject of administrative law in administrative court. So the subject of law in administrative court has been mentioned at the first video. It consists of badan or pejabat tun and also natural person or the private legal entity. So the administrative dispute is happened because badan or pejabat tun is issuing a decree that we recognize as keputusan tata usaha negara that bring disadvantage to the natural person or the private legal entity. For example, Badan Pertanahan Nasional (BPN) issued a certificate on behalf of someone's name upon the building that I consider as my personal belonging, my property. So here, the decisions of Badan Tun bring me disadvantage as a natural person because now there are two certificates upon this house or my property. To cancel the existence of the second certificate, so I have to bring this case to the administrative court. So it will be an administrative dispute. So here, the first subject is badan or pejabat tun. So when you talk about the badan, we talk about the institution. Meanwhile, talking about the pejabat here is talking about the officer. And talking about who is the officer and also the institution that we can consider as the subject of administrative law, I remind you again to look back to your note when we talking about how to distinguish the Bestur, the Regelgeving, and Rechtsstaat in the concept of a state. So badan or pejabat tun here is not focused on the main authority of the institution. For example, DPR, the main authority of DPR is to make the law. And also when we talk about mahkamah or pengadilan here, their main function is to enforce the law. So it's not talking about that, but it's talking about when they do the activities of Bestur. What is the activities of Bestur? They do make basicking. So what is basicking? Basicking is here, keputusan tata usaha negara. So DPR, mahkamah, they can also issue this one, and when they issue this one, it means that they are now rolling a position as a Bestur. So as a Bestur, their decision in the form of keputusan tata usaha negara, it can be sued as administrative dispute in administrative court. But their decision, as the other function of Bestur, cannot be brought as the administrative dispute. For example, when DPR issued undang-undang, DPR is playing their position as the lawmaker. In this case, if you think that the undang-undang is bringing you disadvantage, you cannot bring it to the administrative court and you cannot consider it as the administrative dispute because the law that made by the DPR is not KTUM. Because the law that made by the DPR is not basicking, but it is a law, regals. But when DPR maybe sack you from your position, fired you from your job as the staff in DPR, so the letter of the dismission of your position is based on a decree. So this decree is issued by DPR or a certain bureau or a certain part of the DPR. So this decision is KTUN, even though DPR is the lawmaker. But the product here is not the law, but the product here is the decision. So this decision is KTUN. So because this is KTUN, so you can consider it as administrative decision. So we finish with the understanding about when to define the actions or the officer is badan or pejabat tun, and when they create the KTUN. So that KTUN bring this advantage. Back to the story about the deed of the housing or the land, or maybe the decree of the dismissal of your position in your institution. Let's say DPR, for example, here. So this decision bring you this advantage. Who are you? You could be the natural person, or maybe you could be the private legal entity. Let's say that there is a decision of the governor that for you as the legal entity bring this advantage. Maybe they reject your application for the licenses. They do not issue the documents that you need to running the business. So this decision bring you this advantage. So you want to fight for this thing, so you can sue this decision to the administrative court. So here we can see that when we talk about administrative law in a smaller aspect, the parties that involved in the dispute settlement here is considered as the subject. Back again, subject here means party who can undertake right and obligation. So who is the one that can undertake the right and obligation in administrative dispute? Badan or pejabat tun versus natural person or private legal entity. Private legal entity here means the legal entity is established for the interest of the founder, not for the public interest. For example, limited liability company PT. When I and you, we build the PT, so we build it for our interest to get profit. So it's called private legal entity. But there is another kind of legal entity, but the establishment is not for the one who established it, but for the interest of everybody. Let's say that the state, the province, or the city. The state or the city is established not for the interest for our founding father only, but for everybody in the city, in the province, or for the state, for everybody in the country. So here, the public legal entity like the city, the province, the country, they cannot be the part who become the plaintiff in administrative dispute. But the one who can be the plaintiff here, natural person, us, or private legal entity, for example, PT, yayasan, or koperasi. So the plaintiff cannot be another badan tun, because if the story is badan tun versus badan tun, so it's not administrative dispute, but it's talking about the institution authority dispute, which is the part of the authority of constitutional court, and that is the part of constitutional law. But here we're talking about the administrative law, so it's talking about badan or pejabat tun versus natural person or private legal entity. So this is all the basic that you need to know about the subject of administrative law. To add your understanding, for sure you have to read reference book. So that's why I keep on encouraging you to make the resume, to find more and more references, to give you opportunity to read the books, to understand better about this topic. Thank you.